This is intended as a brief introduction to family relationships, parental responsibilities and rights, and the capacity of children. It does not cover adoption or the legal provisions which aim to provide some protection in cases of domestic abuse, but you are directed to the relevant paragraphs of the text which cover this. The main sorts of adult relationship are marriage and civil partnership. You will be familiar with these, and no more will be said about them. Where a couple has not entered into such a formal relationship, but is simply living together, they will be cohabiting. Historically, in most cases, this had no real legal consequences. For example, if one of the cohabitants died and didn't leave a will, the remaining partner had no claim in the estate of the dead partner, as they would have if they were married or in a civil partnership. Similarly, if a relationship came to an end, there was no provision for a financial settlement, as there is in marriage or civil partnership, where these come to an end. That position was altered by the Family Law Scotland Act 2006. This gave the surviving partner the right to apply to the Sheriff Court for a discretionary payment, and also gave the right to seek a discretionary payment if the relationship came to an end by separation. Note that there is no right to a specific payment. Whether there is an award and the size of the award is at the discretion of the sheriff. The law confers on parents certain parental responsibilities which are set out on this slide. As you can see, these are to safeguard and promote the welfare of the child, to provide direction and guidance, to maintain contact with the child, and to act as the child's legal representative. Apart from the responsibility to provide guidance, which lasts until the child reaches the age of 18, these finish on the child's 16th birthday. Parental rights exist and should be exercised only to allow parents to carry out their responsibilities. The rights, as you can see, extend to having control over the child's residence and upbringing, a right to maintain contact, and a right to act as the child's legal representative. Parental rights come to an end on the child's 16th birthday and will gradually diminish before then. For example, if the child has capacity to consent to medical treatment, this will replace the parent's right to do this. It is, of course, possible for two parents both to have parental rights, and in that case, either parent can exercise these rights independently of the other, so that, for example, if one parent takes a young child to the doctor, that parent can consent to any necessary medical treatment or examination without the involvement of the other parent. Whilst all mothers automatically hold parental responsibilities and rights, the same is not true of the biological father of the child. The father will only hold such responsibilities and rights, first of all, if he was married to the child's mother at the time of the child's conception, or indeed at any time after that, or if he is given them by a court order, or if he has made with the mother and registered a parental responsibilities and parental rights agreement, or finally if he is registered as the father on the birth certificate of the child, although this only applies to births registered after the 4th of May 2006. Anyone can apply to court for the grant of parental responsibilities and or rights, and this application can cover all or only some of these. For example, the biological father of a child who is estranged from the child's mother might be seeking only the responsibility or right to have contact with the child. What children can legally do, or have done to them, varies according to their age, and this slide sets out the position of children at different ages. There is a larger size and more legible version of this in a document on Succeed.